I would like to welcome you, Johanne, to this discussion and talk about sociology of European law, which we are involved in. Could you say something about when you came in contact with sociology of law and what this has meant for you?
Well, I would say that my interests have always been relatively broad. I worked with, I wrote my thesis in Norwegian public law and administrative law, the organization of the Norwegian state, but in a cross-disciplinary manner, using Weber, Habermas, Luhmann's theories, as well as a legal analysis of the changes of the Norwegian administration, the Norwegian public administration, going from being a strongly governed hierarchical system into being a more network-oriented, not loosely organized, but more polycontextually organized. This is in the changes which went on in many European states from the mid-80s till the mid-90s. So you can say that I used also sociology of law theories to write that. So my research has always been as much in legal theory, sociology of law, as in law itself. I have taught constitutional law. I now teach a course in international constitutional law and democracy. I also teach legal theory, which is a legal theory which has an eye to law as part of society. So seeing the variation in law from a societal point of view has always been quite important for me. And I felt that both Habermas and Luhmann and Weber, of course, answered more of those questions. And then I saw that Luhmann also, what got me interested in him, I think, was partly, my first interest was when I also saw how, well, first I read his book on the sociological theory of law, where I think he explains the sociological function of law more clearly, which is that the social function of law is to create normative expectations for normative expectations. That is, creating a specific set of norms which are institutionalized as legal. I mean, there are many types of norms in society, but there are also specifically legal norms which are institutionalized in a specific way and which creates normative expectations for normative expectations, which is explained in his first book on the sociology of law. And then this was developed further by Gunther Teubner, primarily first in his work on his article on reflexive law. Later it's been developed in many diverse directions. But reading his article on Teubner's article on reflexive law, I found very interesting, because there you find a story of the evolution of modern law, more specifically. There you find not just law as this autonomous bubble, which one could say that dogmatic law finds itself within, where there is the autonomy of law, where you have this exegesis on the interpretation of law. And you go also beyond this more sort of simplistic law versus non-law, which parts of critical theories of law have, where the parts of critical theories of law are overemphasize I think a general criticism of the state and a general criticism of law being on the part of the power in society. I mean, that is of course true that law represents power in society, but I was looking for a more differentiated story about law, which I think you can find when you look at theories on the evolution of law over the last 200 years, and which is then found in a very short version of that we find in the article on reflexive law, going from the formal law as formal law with the rule of law, penal law, procedural law, going into emphasizing that the state has also more functions, for example, the functions of the welfare state. And so law has to develop into more
substantial and material
substantive law,
Mm.
material law, substantive, the goals of creating a social welfare state, the goals of social equality, the goals of environment, a cleaner environment, environmental law, working environment, etc. Law was needed as an instrument to enable these more general societal goals. And then, so in the course of that, law developed more institutions. Then in the 70s and 80s, the Keynesian state model couldn't develop further. There were economic limitations to that. And there were theories, a lot of research, both in Germany and I think in the United States, on the implementation deficits, how a lot of welfare state legislation couldn't be fully implemented, and one had difficulties in seeing why. And Luhmann's theories, I think, partly managed to answer some of those, some of the questions on why are there limits to law, why does law why are there implementation deficits in relation to public law. And here Luhmann then, I think this is sort of also the background for this, the theories of the evolution of law, was also the theories of the functional differentiation of society, that modern society is not a hierarchical society with the state at the top and the legislator which can govern all of society, also the economic areas. With the theories of the functional differentiation of society, there is a focus on that there is an economic system, there is a scientific system, there is a political system, a legal system, there is ethics, there is religion, there is art, and these different social functions develop as communicative functions in parallel in society. They interact, but they are also autonomous. And law is then only one of these functions, which means that you get this, that you see the idea that law is not omnipotent. Law cannot solve all our problems, even if the legislator or the sovereign uses law as a vital part of implementing political decisions. We can see that norms, legal norms, are totally vital, crucial in communicating what the legislator wants, what the politicians want. But law alone cannot do the job. It has to work with, it is dependent on the economic system and how that works. It is dependent on the dissemination of knowledge. It is dependent on how society is organized, also politically. So the legal system then is faced with having to try to regulate several relatively autonomous spheres with the different technologies and with the different types of economies. And this is when an increasing amount of legal sociological research showed that a lot of the very optimistic public regulation could not be implemented fully. And that led to then the theories of reflexive law, where Teubner and others looked into, is it possible to have a legal system which also has a great part of a self-regulatory system? That we can say that we only have this, we have a general goal, and then we leave it to the social subsystems to regulate themselves. This was partly tried out in areas of working environment, to say that they developed different types of standards of having a good working environment, and then But then it was with certain, also certain specific technical standards. But then it was up to the different working places to regulate it, to take care of a working environment, because it was it would demand a too large bureaucratic state in order to control it all. So that was part of the thinking around reflexive law. But of course, the criticism was always that reflexive law could be too liberal. To some extent, it meant giving up the idea that we could control power, that state and that the social welfare state, that the social democratic state also could control power. Of course, we still do not have that any solution to that, but I think it was understood that what we called reflexive law couldn't be used in all areas.
When these different systems we are talking about communicate with each other, they use something which could be called structural coupling. Could you comment on that concept? What does it mean?
One could say that a contract is such a structural coupling. In a piece of paper, which is a contract, you can state the economic terms of the contract, and you can state the legal terms. And so in this piece of paper, you couple the economic and the legal elements. The legislation of the parliament is another example of the structural coupling. In the parliament, politicians have their political communication. They discuss from their partial points of view, their political points of view. But they know they have to reach a decision, and in many cases the decision has to be a piece of legislation, a law. A law can only be so and so many pages, and it has to be specific in a certain sense. And when a piece of legislation is passed by a majority in the parliament, then it's, so to say, given over to the lawyers, to the legal system. But the text of a law is then both a political text and it is a legal text. But the politicians can always say, oh, this was a compromise. We know that there are lots of holes in this law, but this was as far as we could get. It's the problem of the lawyers to deal with the holes, the compromises, the unclear goals, the unclear statutes when they go to the courtroom.
Okay, we have talked about Luhmann and Habermas. Would you like to say something about Günther Teubner's contribution, because he has used a lot of Luhmann's ideas at least, but he has also developed these ideas in his own way.
Well, I think I also should add one thing about what Habermas contributes to this discussion is also, I think, exactly the emphasis on legitimacy. But when I try to read it and understand it, I think it can be explained by Habermas is a normative philosopher. He wants to find legitimacy. That is sort of his profession in a way. He wants to see how can we normatively deal with many of the absurd, highly complicated affairs which we do not really understand. He wants to find some way of creating norms, creating legitimacy in that world. Whereas Luhmann is a lawyer and a sociologist, and he doesn't really care if there is a normative legitimacy, and a normative legitimacy here. He has brought to this the very sharp distinctions, which I mean also is vital. So I think because they have different professions, they belong to different disciplines in the sciences, in the humanistic sciences. They see different things, they see different qualities of modernity. So I think instead of putting them up against each other, one should see that they bring different contributions to our understanding of society. And of course, Teubner, I think, also understands this and see that we also need to normatively understand and bring some kind of meaning to society. But he also, I think he agrees with Luhmann in this need for the sharp distinctions. But his contribution has also then been to use both Luhmann and Habermas' theories on a lot of different types of material, on examples. And he has, for example, written on hybridity, and he's written on the concept of networks. What is a network? And I think he's shown in a lot of ways that corporations, we have corporations, many of the largest corporations today are transnational. They do not work, large corporations do not work in nice small nation states, they work transnationally, which means that they will disobey a lot of the norms in maybe the state where they came from. A lot of corporations working in China, in Southeast Asia today, are owned by mother companies in the Western states. In the states where they work, they will use labor law standards which are far below what we would accept. So that is, it's not necessarily a good world, but that is the real world we are living in. And he tries to see that there are transnational corporations which develop norms. They respond to requirements for human rights. They respond to more labor law, but they are also part of a different society, and they also respond to the economic laws, saying that we need to produce things more effectively. So I think from his point of view, you could say that transnational corporations primarily respond to the economic laws of the transnational society, where there is where there are not sufficiently developed, for example, human rights conventions. And so he describes very realistically how society today has developed beyond the public-private distinction, beyond the state versus market distinction, beyond the contract versus corporate distinction, into many sort of hybrid forms, which are difficult to understand, but which are there, and which do not fit into our legal categories. And then he discusses how do we deal with this? How do we deal with this on a legal basis? Should we develop new legal categories, or are we content that certain problems are just solved on a very ad hocistic basis, where we use concepts which are sort of underway, which are not finally defined and developed, but which are only underway. So I think his contribution has been very much to be totally realistic into describing some of the scenarios which law today develops, and new forms of cooperation are developed, which are not the contract and not the corporate, but the network. And that network may be a very unclear, very uncertain, a too uncertain concept for the legal system traditionally, but it is applied, it is used, it is extremely productive, and so we then just have to deal with it.
And it's kind of interplay between formal law and self-regulated non-formal law, I guess, and that might be the new development compared to private-public distinctions and so on, I guess.
Is it then so that law only repeats what is in the social, the technological semantics, and doesn't do anything more than just convey it? Does it lose its autonomy? And that we have pieces of law where we could say that that the idea is that we can say that it oscillates between being law and not being law. That law and non-law comes very close to each other. for example, the regulation on genetically modified organisms, which are used in agriculture, which is used in plant production, medical production, etc. There's been a very substantive, significant economic corporate pressure into accepting that we use genetically modified organisms in the production of medicines and agriculture, even if we know that using genetically modified organism in, for example, the production of soy and maize and other plants, we also risk seriously destroying the ecological balance in the nature. So there are severe risks, severe ecological risks in using genetically modified organisms in the natural environment. But the risks of using genetically modified organisms, we have not been able to, I think, come up with a good enough language for, or a good enough representation for, both neither in politics nor in law. But the pressure to to use genetically modified organisms in industrial agriculture and in medical industries. There's been a language for that, but there's not been a sufficiently effective and precise language for the risks involved. And we can say that law sort of becomes trapped in this game, that law repeats what other semantics say. It's very difficult for law to take some of these conflicts out of their social environment and say, and confront these areas and say we do not have a good enough semantic for some of the values involved. So law becomes trapped by the power which is in the different economic systems, in the different technological systems. Well, I think we can say that modern society expands in many different ways. It expands through what we have called functional differentiation, which is also a form of increasing specialization in all areas. But it also, modern society is also expanded then beyond the borders of the nation states, so that the function systems, particularly the economic system and the different scientific and technological systems, the art system, the religious system, will expand to also the global and the transnational level. I mean, most knowledge is, of course, knowledge and technology is, of course, culturally based in a certain sense, but it's also conveyed and continuously communicated on a global level. One other obvious example is the internet. I mean, the internet is a global technology. It is not. It may have been started in the United States, and it may still have substantive parts of of the development of new software and hardware in the United States, but now also in other states. And of course, the ICT, information and communication technology, has created new technologies, which has also then created or given support to a more global world. Because I think for law this is a challenge in terms of the fact that the legal language is, I think, a very quite vulnerable language. In the area of the nation states, the legal systems for a very long period, 200 to 300 years, developed significantly within the different nation states, which meant that there was to some extent, a given conception of the reality of what society was, what the main values were, how society was and should be organized. There were all these given conceptions of society, which I'm sure we had in Swedish law, in Norwegian law, in German law, in British law, certain conceptions of society which just were there without being repeated every time you made a new piece of legislation. So within the nation-state model, you had one or in some cases 2 or 3, but often usually one main language which law was developed within, and where there also were inherently a consensus on what the different words, the concepts meant, and what the different conceptions of society, what the conceptions of the different main values were. And this meant that you have some. This means that there is some kind of limitation to the complexity of modernity, because you have some given common conceptions. It's of course clear that when we then move on to make legislation on the European level within the European Union and the European Convention of Human Rights, and when we make law also on the global international level with the United Nations, with the WTO, and with lots of other international treaties, then we make legislation, we make law for much more heterogeneous societies. Because the UN Declaration of Human Rights is sort of the mother of the later conventions in other regions and states, but and the UN conventions of law on conventions on human rights are also some of the main documents in human rights. But when we implement human rights today, we have regional conventions, and then we have nation-state legislations in order to support a more detailed implementation and interpretation of human rights. When we now increasingly have also effective, at least regional courts on human rights, like we have the European Court of Human Rights. Under the UN there are committees, not courts but committees, but which make recommendations for the interpretation of the conventions. Of course, this is a much more complex operation to go through, because because law is not only the autonomous law. Law is then also something which is part of very many different societies at the same time. Of course, the social welfare rights, rights connected to the family, rights connected to the right to a good environment, even freedom of speech, freedom of religion, are interpreted in different ways in different regions of the world today. But one of the challenges is then that some, what we call globalization consists, of course, of many different dynamics. Globalization is not one thing, it's many different dynamics which work in very different ways. But one of the most dynamic and effective parts of globalization has been the economic dynamics, creating world markets which are by no means perfect and even, but there is an enormous amount of international trade today. We buy most of our consumer goods. Most of the consumer goods bought in Europe is produced in Southeast Asia and China. The natural resources we get from all over the world. So there has been created an enormous economic interdependence in the world, which has probably necessitated some kind of World Trade Organization. One can discuss if the present World Trade Treaty Organization is a good one, but some kind of coordination has become necessary.
You say something in one of your articles that law and politics have much harder time to move across borders, while economy and science are easily moving around the globe, so to say. Is that something which fits into what you have said right now?
Yes, this has been said, I think, by several theorists, that the economic system is more easily translated, because in the economic system it's money which is the value. And we have ways of translating between dollars and euros and British pounds, etc. In a very sort of direct kind of way. So if we produce something here, we produce a book and we say it costs $100, then it can be easily disseminated throughout the world. But if we in this room come up with a norm on a specific formulation of freedom of speech balanced against, for example, hate speech, that is a much more culturally based norm and culturally based fact. So when in the political system and in the legal system, the communication is much more based on culture and social communication, as this has been developed historically and of course also linguistically in the different parts. So when we translate political documents and legal documents to both to other languages but also to other cultures where the same words may mean different things. Also, the word respect, for example, we know means very different things in different parts of the world today. Having respect for other people, having respect for religion is something which means very different things in different parts of the world today. And that means that to create both the everyday type of communication and then political communication, legal communication, also ethical communication, that is much more complex to translate both to other languages and to other cultures. But of course other systems also produce norms, but they do so with a reference to cognitive references, with references to specific forms of knowledge, to a specific economy, etc.
And I guess that both economy and science, they are characterized by the fact that they implicitly create normative expectations out of cognitive expectations. I mean, out of investigating how the world functions, you would say.
And also to some extent, both the economy and parts of the sciences, particularly the more hard sciences, the natural sciences, they refer to empirical elements in sort of hard way. I mean, to plants, to geology, to chemistry, chemicals.
Which are the same all over the world.
Which are the same all over the world. I mean, a recipe for a certain medicine can be translated and used wherever. And natural sciences and industrial technologies have, of course, expanded enormously in later years, both because they can easily be translated and because you have the internet. So once you have a new medical recipe in one laboratory, it can be in 1 second. It's disseminated throughout the world, so it's there. Whereas if there is an ethical problem about applying that medicine, that may be a much more complex argument to formulate in the different languages.
How about the concept of legitimacy?
No, I think legitimacy is a very important concept in a world where we, in some cases, are close to what we could call the boundaries of what we should or ought to do. When we develop new technologies which may have significant negative effects, but which it takes a lot of time to see whether they have these negative effects, then of course the temptation to take that into use. If there is, for example, a medicine which seems to be effective, of course it's very temptatious to apply it, even if we may know that there may be side effects to this, where these are substances which stays in the body and which then moves on to new generations, etc. But it's very, of course, it's very tempting to, if you know that you can save a life now, you're very tempted to use that medicine. And so what we haven't sufficiently developed is concepts and a language for how we talk about ethics and legitimacy. And I think it's very good. It's very sound to couple the concepts of ethics and legitimacy in a world where we very often walk on the boundaries of where we should walk. Well, I mean, any crisis we have today, the financial crisis, the climate crisis, etc., the politicians will have to talk about it, and they also will have to make some decisions. And the political and the legal systems have been developed to do this. But I think it's also enormously important that we also know that these decisions do not necessarily have to be ideal, I mean, even if they're not carried out to their full purposes, these languages and the institutions still exist and still may have legitimacy. So the idea is that the mere fact that these the themes, the conflicts, the problems are addressed by politics and by law, and that decisions are made in an attempt to deal with it, is vital. Of course, it may make both law and politics illegitimate if the problems are never solved, if they become too ineffective. And that is, of course, I think one of the big challenges of modern societies. That, I mean, we have that challenge in relation to the internet today. The internet is a type of society which is very difficult to regulate. The events of the last month in Norway, where we had this large bomb and the shootings, which are very hard to understand in a Norwegian society. One way of understanding them is that this bomber found support in small groups, closed groups on the internet. I mean, in the old civil society, in a newspaper civil society, where we have libraries, open newspapers, etc., any argument is heard and then can be met by another argument. On the internet, you can have lots of closed societies where you only meet people who mean exactly the same thing as you. And in those small niche societies, you can drive a certain sentiment to its absurdity and to very destructive elements. So I think that is an illustration of that technologies today may develop things which where also law and politics, as we have developed it today, also do meet their boundaries, or at least are challenged in very serious ways. The internet is also something which is extremely difficult for a state to control, both for good and for better or worse. Of course, it gives a lot of liberty. I mean, Facebook and Google have become enormously powerful, comprehensive institutions of communication. But of course, the problematic sides are that it's difficult to control the use of hate speech. It's difficult to even know it's there. So. So it's a social world which is very different from the one which classical modernity was made in. If there's one thing one could add, is that I think one of the important contributions by Luhmann's theory has been to make us understand that law only has a certain function, that law is not omnipotent. We cannot demand that law changes society for us. Law is met by economic power, technological power, sovereign power, by war. And law cannot alone change those things. So I think it's extremely important to see that law is a normative language, which is highly institutionalized. And it's by its institutions, both the parliamentary and the judicial and other communicative institutions, that law becomes important. Law lives on its institutions and its language. But in order to really implement change, which has been decided on, law has to work with and somehow communicate with the economic part of society, with knowledge, with the creation of organizations which work, with education. And I think that is, because many other, even Habermas theories and other theories of law can often fall prey to the fact that they demand too much from law. and then law fails, and then law is seen to be not a disaster, but law has failed and the legislation has failed, politicians have failed. But I think it's very important that this argumentation can also repair too high, unrealistically high expectations to what politics can do. That both politics and law are very vulnerable languages, and they are human-made institutions. So we create them, but that also means that they are very imperfect and should be seen and accepted as that, because it can also incite a lot of also political unrest if too high demands are made onto law and politics.
Isn't it a reason to discriminate between different systems? Social system would be the systems where social interaction is the guiding principle and the driving force, while in other systems you have more scientific-based arguments or professional developed arguments.
Well, one other way of formulating this is to say that that there are what Luhmann calls social systems. It consists of function systems, which are the generalized ones. But then you have organization systems and then interaction systems. And they work on different levels. So that both a corporation, a university, a ministry can be an organization, or just a simple workplace can be an organization system. And in such an organization system, you have an enormous mix of interaction between the different function systems. And so one criticism of Luhmann has been to say that he did not sufficiently develop this idea of social systems on the level of organizations and on the level of interactions between persons. Teubner has done this to a certain extent, and some of us others also applying Luhmann's general theories try to do this. And when you do that, I think you develop a much more productive and interesting theory also for a more micro level analysis of society, where there are where there may be an enormous amount of different structural couplings working together, and where you will find elements of maybe a scientific argument, but processed and influenced by the social atmosphere which it is part of. And where you may find some organizations where there is a very sort of hard science conception of that, but other organizations where they couple science and ethics in a totally different way. So I think that would be a way of putting it, that that you could do, and I think that is the way forward today, to try to make analysis of organizations, bigger or smaller, where there are combinations of all these more instrumental communications, but they're also processed in specific contexts. In the context of a university where there's education, in the context of a hospital, in the context of an NGO which works with development, in the context of an old age home, but of course also in the context of an instrumental corporate law firm or a corporate finance firm. And so I think then you would see many more nuances also in how the legal language, how scientific, how the economic languages develop over time, and where, for example, in the economic sphere, we'll find organizations willing to work on a non-profit basis, and where you'll find lawyers willing to say that we don't go after everything where we might find money. We don't use litigation all the time. We go for compromises. You may use the example of, well, generalize the example of South Africa and their way of making peace after apartheid, with not using courts, but using different types of dialogue in order to do this.